Hello everyone, my name is Juan Valentin and I'm a mechanical engineer who loves to play softball in my spare time. I was a patent examiner for 12 years at the U.S. Patent and Trademark Office before transitioning into my current role as an education advisor, also at the USPTO. And this is where I get to have fun conversations about intellectual property with amazing inventors just like yourselves.
Hello, everyone. My name is Jorge Valdez. I'm a chemical engineer who loves to fish in my spare time. I was a research scientist at AT&T Bell Labs before I joined the USPTO as an education advisor, where I get, just like Juan, to have these fun conversations about intellectual property with amazing young inventors like yourselves. The USPTO is on social media. Like us on Facebook, follow us on Twitter, and join our national conversation by hashtagging the amazing work you do around the invention and innovation, hashtag USPTO STEM.
After today's session, you'll be able to understand what intellectual property is, identify different types of intellectual property, explain why intellectual property is important to your project, understand how to create and protect intellectual property, and finally, you'll get some tips before you apply for a patent in the United States.
This is our legal disclaimer. In short, it states that any references to commercial products or services are merely for education purposes only and not an endorsement by the federal government.
So at the U.S. Patent and Trademark Office, we do three core things. Number one, we issue or grant patents. Number two, we register trademarks. And lastly, we advise the administration on matters involving intellectual property. And this includes not only patents and trademarks, but also copyright policy as well as trade secrets.
The USPTO has 4 regional offices around the country, and our headquarters is located just outside of Washington, D.C. in Alexandria, Virginia. So make sure next time you are in the DC area, come visit us and check out our National Inventors Hall of Fame Museum on the ground floor.
As America's innovation agency, the U.S. Patent and Trademark Office is committing to fostering innovation and growth by creating a reliable, predictable, and high-quality intellectual property system. We'll discuss in more detail what intellectual property is in a moment.
Much of human progress depends on innovation. It depends on people like yourselves coming up with ideas to improve life. When you think about penicillin or cancer treatments, electricity, or even the silicon chip. For this reason, societies have a big interest in making sure that as many people as possible have that opportunity to become scientists, inventors, and entrepreneurs. It's not a matter of fairness. It's really denying opportunities to talented people can end up hurting actually everybody. A study that was conducted by a research team at Stanford, MIT, and Harvard, and the London School of Economics concluded that we can actually quadruple the rate of innovation in the United States by increasing invention rates among women, minorities, and those from lower income families.
So the study we just referenced, we also refer to it as the Lost Einsteins, also concluded that exposure to innovation substantially increases the chances that children become inventors. Children who grow up in areas with more inventors and are thereby more exposed to innovation while growing up are much more likely to become inventors themselves. For example, if you grew up in San Jose, California, you're about 5 times more likely to become an inventor than a child who grows up in Arkansas or maybe Oklahoma. That is why we need partnerships like Oklahoma Education and Industry Partnerships to change the equation around. The top 5 cities in America that produce the most inventors per capita are San Jose, Minneapolis, Madison, Wisconsin, San Francisco, and Detroit.
Wow, Juan, that's fascinating.
Yeah.
So last year, the USPTO released a white paper entitled Progress and Potential, a profile of women inventors on US patents, which clearly showed that women still comprise a very small percentage of patent inventors, about 12%. So women, like other underrepresented groups, are among these lost Einsteins that Juan just referred to. People who can contribute valuable inventions that have been exposed to innovation, one, and have a greater access to the patent system.
There really is a need to promote innovation, Jorge. So what can patents do? Why do patents matter? Well, they promote innovation and they help safeguard your inventions. They help companies grow. They benefit the community by making new goods and services available to everybody. They provide personal growth, development, and advancement. And lastly, all of this is good for your career technology students who are about to enter the workforce. They really do help everybody.
If you look at intellectual property industries, right, they are critically important to the U.S. economy. They provide 45 roughly million jobs, 38% of the United States gross domestic product, and they're also higher paying jobs.
Let's begin by demystifying intellectual property. And I've been saying intellectual property a lot. I'm going to start to say IP. That's short for intellectual property. So let's demystify IP.
So take a moment to look at the different types of intellectual properties that are portrayed in this picture. So Juan, I see one example, which is copyrights. That's the C, the little C with the circle around it.
I see that. I see brands. And when I read brands, I think of trademarks, and that's also on there. And that trademarks are the ones with the R with the circle around it.
Cool. I think I spotted another one, Juan. I see patents. Love these. Okay, it's your turn.
All right. I think we're getting down here. But I also see licensing, which is an interesting concept, but I don't really think it speaks to, or it is intellectual property, because licensing is like giving someone permission to use something, but you're still the owner of that intellectual property.
Yeah, Juan, I definitely agree with that. Great job. Great job.
So there are 4 types of intellectual property that we're going to discuss in today's workshop. We're going to talk about patents, trademarks, copyrights, and trade secrets. They all share one thing in common. These are all creations of the mind. They can be an invention, it could be a poem or a song that you've written, a logo that you've created, or even a secret formula. Right? Different intellectual property offers different types of protection, and it's important to learn the differences between each one. A person or a company may be able to use one or more different types of intellectual property. Intellectual property rights allow us to protect and control how our inventions work, distinctive names and brands, original writings and artwork that are used. They also provide us with guidelines for use of other people's intellectual property to make sure we are infringing on their intellectual property.
That was a great introduction, Juan. Let's dig a little deeper and let's define what is a patent, right? The patent is a right. It's a property right that goes back to the U.S. Constitution. Wow, that's a long time ago. And it gives people the right to exclude others from making, using, selling, offering for sale, or even importing your invention. It lasts for a limited term, and we're going to show you that in the next slide, and it's territorial. So if you get a patent in the US, it provides protection only in the United States. So there's no such thing as a worldwide patent. And
so there's 3 types of patents. We have a design patent, which gives you coverage for 15 years from the date of issue. You have a plant patent, which gives you protection for 20 years from the date of filing, and then a utility patent, which gives you protection for 20 years from the date of filing as well. Design patents protect the way something looks, its ornamental value, the ornamental look and feel of it. And little small fact, in 1930, Congress passed the Plant Patent Act. This created a distinct type of patent to protect new varieties of asexually reproduced, non-tuber propagated plants. So as the picture shows here, plant patent number 1 for a new type of climbing rose called the New Dawn is still very popular to this day. Really cool stuff.
That's pretty fascinating. So if we take the utility patents, which really are the most common, so when you think of patents, most people oftentimes refer to them as patents, but most of the common patents are utility patents. They come in 4 flavors. And think about this. The utility patents protects how an invention works or functions or is made. And if you're trying to get a utility patent, it's got to fall under one of these four legal categories: a process or a method for doing something, sort of like the CRISPR technology to make the new COVID vaccines. It could be a machine. I'm sure most of you have seen a 3D printer before and know or have heard about it. It could be some kind of product or an article of manufacture, like a Frisbee, or it could be a composition of matter. And there are a lot of examples in this category with pharmaceuticals and drugs that help treat cancer and other types of diseases. So those are the four different categories under which utility patents are covered.
Sticking with the theme of utility patents, these are the three requirements to receive a utility patent. It has to be new. We call that novelty. It has to be useful. We call that utility. It has to do something. And the third one is non-obvious. It has to be non-obvious.
Well, since you brought it up, let's talk about it, Juan. What does non-obvious mean besides the obvious? Get it? That was funny. Anyway, non-obvious means that you can put different inventions together to create something new and different and perhaps really cool. So, for example, before the electric car was invented, let's say, for example, the Tesla and other cars, we had automobiles that ran on, and we still do today, on gasoline. And we also had electricity, right? Was putting those two things together, obviously? What do you think, Juan?
That seems obvious, isn't it, or no?
Probably not. I don't think it was as easy as sticking a cord on a Yes, I think we should have that conversation with Elon Musk and ask him what his thoughts are on that.
Yeah, I love this story of the popsicle. So here's a story about a little boy from Northern California who one day left a cup with a sugary drink mix and the stir inside the cup outside of his house after his parents called him in for dinner. And the winters in Northern California are pretty cold, and they forgot about the cup, left it outside. When they woke up the next morning, they found the cup frozen. And remember, the stir was still in the cup. So when he pulled the stir to try to pick the cup up, out came this frozen concoction, and he gave it a lick, and boom, light bulb moment, the popsicle was born. It was first called the Epsicle, but then the name was registered as a popsicle, as the official trademark. And that's why you'll see the R with the circle around it, which means it's officially registered with the trademark office. And the trademark today belongs to Good Humor Breyers. They're the owners of that popsicle trademark. And so on the left, you'll see the actual patent drawing from the U.S. patent that was issued in 1924. And it's entitled Frozen Confectionery. This is for a utility patent for the process of making a frozen confectionery, aka process of making the popsicle. So wow. Really, really cool.
Pretty cool at such a young age, right? Got a patent.
Yeah.
U.S. patents can be used to get ideas to create new or even improved inventions. So they can be really a treasure trove for anyone out there that wants to be inspired to come up with inventions of their own and get their own patents. And that's how technology progresses. What you see here is a picture of a patent that I would never use because I would never get on with those shoes and slide. But that's the Heeley shoe that some of you may be familiar with. It was issued back in 2002, and it was kind of a toy of some sort that you kind of slid on the floor. Would never catch me on those shoes at all.
That looks dangerous. That looks very, very dangerous. So let's do a quick knowledge check to see if everyone's been paying attention.
All right, here we go.
You have to be an adult to apply for a patent. True or false? I'll give you a couple seconds here to think about it in your head. All right. Dr. V, let's see the answer. False. You do not have to be an adult, as we just explained with the story of the popsicle. Frank Epperson was 11 years old and he's the named inventor on the patent. So there is no age requirement to file a patent application and receive a patent. So that's good news for you, all you young researchers out there, pouring your hearts and souls into your inventions and your innovations. you absolutely should consider whether it's a good strategy for you to protect your inventions through patent, for sure.
Awesome. All right, I got another one here. What type of intellectual property, or I'll call it IP just for short, since we're going to use IP, protected Frank Epperson's invention? Was it a trademark, a patent, a copyright, or a trade secret? Give you a second to think about it. And the answer is, yeah, absolutely, a patent. And we showed you those are actual drawings that were included in the patent when it was applied by or submitted application by Frank Epperson. All righty, let's move on.
Continuing on. In order to be granted a utility patent, the invention has to be new, useful, and non-obvious. It has to be proven. It has to be the same as other inventions, or it just has to be better. Which one do you think it is? There's a lot of good options here. Dr. V, survey says, ding, ding, ding. It could also, here you see the answer is new, obvious, useful, and non-obvious. However, it could also be better, but better is not a requirement for getting approved for a patent. So we just need to remember the 3 things your application for invention needs in order to qualify for utility patent. And those 3 things are: your invention has to be new, it has to be useful, and lastly, any changes, additions, or improvements on your invention must be non-obvious. New, useful, non-obvious. 3 things. Utility patent.
Cool. I'm beginning to get the hang of this one. All right. Our next question is, you are allowed to study patents to get ideas to create new and different inventions of your own. Is that statement true or false?
Dr. V.
And the answer is absolutely. It's disclosed. You can go search for it. And that was one of the things that was in the Constitution, that the government would protect you for a certain limited amount of time, provided in exchange for it, you as the inventor sharing your information so that others can learn from it, get inspired, and improve upon your work. And that's how we have technological improvements.
Research is the name of the game, right, Dr. V?
Absolutely.
Anatomy of a patent. So every patent has certain components, and I highly recommend before you file for any patent application, you really get to know inside and out what a patent looks like. So here we show you what the cover of a patent looks like. It includes title of the invention, the date the patent was published. We call this the publication date. It also has an abstract, which is a short summary of your invention, similar to many of your research projects, the abstracts, the descriptions you created for those. It also lists all of the inventors who helped create this invention on the patent. And there's also a drawing, one drawing of the main parts of the invention, as well as lots of other useful information located on the patent cover. Now, if you turn the cover over, you go into the patent, past that cover page, there's a lot more information as well. And so some of that information after the cover includes a written description that explains in detail how your invention works and how it's made or used. This is very important to include. In some cases, there's also additional drawings or graphs that go beyond the initial drawing that you see on the cover page. All the drawings plus the written description are used to enable the reader to fully understand how to make and use the invention. All right, that's important. The drawings and the written description go together. The last section of the patent is where you're going to find the claims. The claims define the scope of protection for your invention and are written in such a way as to describe the inner workings of all the parts of your invention, how everything comes together and works, what it does. So in other words, the claims define the legal boundaries of your invention, and they're similar to a deed to a property that you would get after buying a house or something similar of that nature.
All right. Thank you for that explanation, Juan. Here is an example I pulled of a hypothetical patent for a chair, some kind of chair. It claims a chair, the claim one is a chair comprising the following components. What kind of patent could this be, Juan? Is this a utility, a design patent, or a plant patent?
Well, we know it's not a plant patent, right? I don't think that could be called a plant. So we can exclude that one right away. Let's see here. Design patent numbers always begin with the letter D before the patent number. So that's a little tip for you. I just gave it away. So let me look at this patent number. There's no D here, so this isn't a design patent. So by process of elimination, I'm concluding this is a utility patent.
Sounds
What do you
good.
think, Dr.?
I agree with you, Juan. I think that's a great decision tree there that you went through. Okay, let's move on and talk about a little bit of who can be an inventor on a patent. Really anyone. Conception refers to anyone who contributes either directly or indirectly to one or more of the claims that Juan talked about that are located at the very end of every patent. So anybody who contributes to that can be an inventor. We're going to take you on a quick journey of the patent application. It starts with an idea, right? You have an idea, and that's awesome, right? And then you have to decide, is your idea or your invention worth protecting, as Juan mentioned earlier. And this is often the case of thinking about a business plan or a business decision. That's a determination that all inventors and entrepreneurs need to think about at the beginning of an idea. We're going to show you a short clip of a very famous pioneering inventor called Philo Farnsworth.
My name is Philo Farnsworth, and I invented electronic television. I think a genius is simply someone who keeps pushing, keeps exploring, keeps seeing what is possible. I think we are instruments of God, put here to make something better, to improve the lives of man, and that moment of creation, of inspiration, of what people call genius, is God speaking through us. David Sarnoff is one of the most brilliant businessmen I've ever known, and he's one of the most hardworking people I've ever known. And in that sense, he is a genius, but his realm is not in science. As president of RCA, they accomplished incredible amounts. They made radio what it is, and they popularized television in a huge way, but a business genius, not so much a scientist. I had the first designs for electronic television. I created them when I was actually still a freshman in high school. David Sarnoff and his team of scientists disputed that claim for many, many years, partly involving a trial process, attacking our funders, things like that. There was a time during the trial and appeal process, it's not something I like to talk about, but things were particularly hard. All of our financial backers for television had pulled out in favor of RCA. My wife, Pam, and I, we didn't have much then, and the idea that television would go on and I would not be its inventor, that was hard. But ultimately, my patent was recognized as the first one for electronic television, and thus, I am the inventor of television. For me, it was never about making the most money. It wasn't about running the best company. It wasn't about running the best business. All of those things would have been nice, sure. My goal was for electronic television to exist at all, and to be known rightfully as its creator. So in that sense, it was a victory. All the rest was just trouble along the way.
All right, so I hope you liked the clip. The question after seeing the clip is, what type of utility patent do you think Philo Farnsworth received for his invention of the television? And Juan, I'm going to go back to your telling us about the front page. I went to the actual patent of Philo Farnsworth, and I read the following sentence. The abstract, similar to the abstracts that you submit for ISEF, says and states, and I quote, "This invention relates to a television apparatus and process. That is, it is directed to an apparatus and process for the instantaneous transmission of a scene or moving image of an object located at a distance in which the transmission is by electricity. Wow, the inventor of the TV. But in the abstract, it calls for a process and a machine. So if your idea and your invention falls under one or more of these categories, then it's eligible to receive a utility patent. So Philo's patent was a utility patent for the first television, which included a machine of some sort or an apparatus and a process for making TV work. That is pretty cool, right, Juan?
That is really, really neat. And a student invented the television? Like, how cool is that?
A sophomore in high school.
That is an amazing story. Really good stuff. Good stuff. The patent application journey. Here's a couple things we want to talk to you about as you begin your journey to filing a patent application. Number one, don't be afraid to champion your idea. All right? You need to understand it. It's your idea. You need to champion it. But it's also best to maintain confidentiality prior to filing your patent application. It's very important. You should consult with an attorney about safe ways to disclose your invention before filing a patent application. I would note it's not mandatory. You don't need an attorney. However, this is a legal issue. And if possible, consult with an attorney before you disclose. So just keep that in mind. After you've come up with your idea, you have to draft an application. Now it's time to write up the patent application. So what do you need to disclose in your patent application? Great question. Glad you asked. We're here to help you. So a patent is a quid pro quo. This is Latin for an exchange. It's an exchange of information. So we, the government, are giving you a right, right? But you have to give us something in return, right? And so we're giving you the right to exclude, as Dr. V noted earlier, a patent is the right to exclude others from making, using, selling your invention for a limited period of time, right? And so that is what we're giving you. What you're giving us is you must fully disclose your invention so that the public can benefit from it and learn how to make it, learn how to use it, and they can be inspired to make it different or improve it somehow, right? So that's the deal. Okay, so that's the step 3. The last one is to actually file your application with the USPTO. You'll also need to file a sworn oath or declaration that you are the actual inventor of the invention that is described in that application. And you can expect your first communication from the U.S. Patent and Trademark Office about within 15 to 18 months from filing that application. It could be sooner, it could be a little longer. That's on average. It just depends on the technology that your invention is in.
So Juan, you told us, so we talked about that the U.S. Patent and Trademark Office does patents, but we really haven't talked too much about trademark. We're going to tell you a little bit about the registration process and why trademarks are important. The trademarks are all around us. Traditionally, trademarks can be identified by one of 3 symbols that are shown on this slide: the TM, the SM for service mark, and then the R with a little circle, which means it's registered with the United States Patent and Trademark Office. So service mark is the same as trademark, but it's used to identify services rather than products or goods. Right, as I mentioned, R with the circle is reserved for federally registered trademarks that are registered with the U.S. Patent and Trademark Office. So what are trademarks? Trademarks are basically serve the purpose of identifying the source of those products or services and distinguishing those products and services among different competitors. Trademarks, there are different types of trademarks. They can be either a word, they could be a design, or they could be a combination of both, as are shown on this slide. So the question is, why are trademarks important, and particularly to consumers? And the question is, if I asked you, would you brush your teeth with the tube on the left or drink the beverage on the right?
No.
Of course not. You wouldn't, because you don't know what's inside. So trademarks serve the purpose of identifying what's in the package, and you get to say, oh, I like this brand of soda, or I like this brand of toothpaste, or whatever the product might be. So Juan, you mentioned earlier that there were 4 types of intellectual property. So far, we've covered patents and trademarks. Can you tell us a little bit about copyrights?
Yeah, certainly. Real quick, I love trademarks because, you come up with this amazing invention, you protect it with a patent, but how are people going to know it's yours? Through your trademark. That's why trademarks are super important. But anyway, so copyrights protect original works of authorship. They can come in many forms, whether it's artwork, it could be sculptures, books, videos, movies, songs, musical compositions. The important thing to remember is about copyrights is these protects expressions of an idea, and they must be put in a tangible form. Right, so you either, whether it's a drawing on paper or a book, words written on, a napkin, or some sort of video recording, it has to be recorded or stored somewhere that you can access it and look at it. So these are the important things to remember about copyright as well. Copyrights last the life of the author plus 70 years. So that's important to remember. That they last a while, much longer, significantly longer than patents. Remember, patents were 15 years for the date of issue for design patents and 20 years from the date of filing for patent utility. And then I don't think Dr. V mentioned it, but I'll mention it real quick. Trademarks last forever as long as they're being used in commerce. You need to continuously use it in commerce, in business. Otherwise, the trademark will expire. So that's important to know about copyrights and the other forms. Trade secrets. Trade secrets are fun. They are the 4th type of intellectual property we're going to talk about today. But as the name implies, you have to keep it a secret. You have to keep it a secret. You don't want to tell anybody. And I'm whispering, and I hope you can hear me right now, but don't tell anybody. It's a secret. All right, we don't want to know about it. All the other forms of intellectual property, you have to go to the government and show them and tell them, like patents, trademarks, copyrights. Copyrights go to the Library of Congress, but you still go somewhere and you give them the sample to them or a representation, and you tell them. Trade secrets, no one wants to know. Don't tell us. Keep it locked up. Keep it hidden. You have to prove that you have gone out of your way to try to keep it a secret. A couple of good examples of trade secrets on the screen. Krispy Kreme, the recipe for the dough of the donuts, the recipe for Coca-Cola, but it's not just recipe. It could be marketing lists. It could be supply chain of some sorts. So can you think of a disadvantage of using trade secrets in your business? What do you think? What do you think? Are there any disadvantages of having a trade secret? Well, I'll tell you one real quick. It's only a secret until it's not a secret, right? So a patent gives you a guaranteed amount of protection. For utility, 20 years, right? But trade secrets, they could last 100 years as long as it remains a secret. But if somehow you go to the coffee shop and you leave your secret on the table, you go to the restroom, or you get up to go get some more sugar for your coffee or something, and someone looks down and sees it, well, they haven't stolen that. You've left that out in the public. That's now public information. Someone took it, and now they can run and do whatever they want with it. There are recourses if someone does actually, illegally obtain your trade secret. You're going to have to take them to court. But unfortunately, the sad part about it is it's no longer a secret. So just think about that. It's all about strategies.
Wow, that's a lot of information, Juan. How am I supposed to get some help with all of these forms of intellectual property? Well, the good news is that the United States Patent and Trademark Office has a lot of ways in which we can assist you through help and resources. And so we're going to tell you a little bit about that before we close out. Our first stop is for educational resources at the USPTO is our very own Kids pages. There's the link. Here you'll find activities, resources, programs, videos that are really cool for educators. You'll have lesson plans. you name it, for both teachers, parents, and students. So I encourage you to come and visit us. Don't let the word kids, there's stuff there for everybody.
Yeah, no, our kids pages is awesome. On our kids pages, you'll also find the inventor collectible cards, and these are one of the hot items that you're going to find on our kids page. I call them trading cards, inventor trading cards. I love them. They're physical. We actually hand them out. So if you catch us at a science fair or at a STEM festival or exhibit booth, if you see USPTO, there's a really good possibility that they're going to have trading cards with them. Go up, ask them if they have any, collect them. You can trade them with other people. We're trying to make them big, so you're going to help us make them big. So if you ever get your hands on some of these trading cards, keep them. They're awesome. You can turn them around. You can learn about the various inventors that are featured. There's descriptions about their inventions. We use them to help inspire kids to tell real life stories from a diverse group of inventors. You can, like I said, you can pick up cards at a lot of the outreach events we do around the country. If you want to request some cards, if you're an educator, you feel free to email us at education@uspto.gov. That's education@uspto.gov. Collectible cards. Awesome.
Yeah, and we'll put that email up at the end so that you can have it. In addition to our kids pages, we have collaborated with other federal agencies such as the National Science Foundation and NBC Learn to produce 2 collections of the science of innovation designed to inspire everybody to become future inventors and entrepreneurs. And again, these are videos with that showcase real inventors. For teachers, there are lesson plans for both middle and high school students. And each year, the USPTO runs an annual National Summer Teacher Institute, which is essentially boot camp for teachers. It's a 1-week-long program where we bring together teachers from around the nation to help them learn about innovation, STEM, intellectual property, and how to bring these concepts into the classroom with the purpose of, again, inspiring our future inventors and entrepreneurs.
Yeah, those are great resources, Dr. V. We also have the Inventors Assistance Center, and the Inventors Assistance Center provides patent information and services to the public. It's staffed by former supervisory and experienced patent examiners who can answer general questions concerning patent examination policy, as well as procedures, timelines, forms you have to fill out, things of that nature. What the Inventors Assistance Center cannot do is provide legal advice. So that's important to keep in mind, but it's still a really good resource for you as you go along your patent filing journey. We also have the USPTO Pro Bono program. There is some stipulations to qualifying for the pro bono program. There's a gross household income stipulation. It is a regional program that's dependent, but it's usually limited to 300% of the federal poverty guideline. A single person can have an income of up to, these incomes change, so you're gonna have to check the poverty guidelines, but there's a limit. The limit increases with the amount of dependents. Basically, what you need to know about the pro bono program is it's regional around the country in the US, and if you go to each pro bono webpage from around the country, they will show you the different specifications and qualifications for that particular program. And this is all located on our website. But I love it because the pro bono means free legal service. So these are actual attorneys, licensed attorneys that are volunteering their time to work with inventors and helping them prosecute their patent application by helping to create their specification and then file it and do the prosecution back and forth with the patent examiner. So if you qualify for this program, that's a huge win for you. And you can go on our website and get more information. So we also have our law school clinics, which is another great resource. So if you don't qualify for the pro bono program or you're not selected, don't worry. You can try law schools. So the law school certification program allows students that are enrolled in participating law schools around the country to practice and prosecute patent applications before the USPTO. Now, they are operating under the guidance of a law school faculty clinic who is their supervisor. And so this is really a win-win situation for you as an inventor because you're getting free legal help And the law students are getting help and experience prosecuting patent applications. So it's a win-win for both parties. And I think it's a great program. You can get more information about that on our website to see the different law schools around the country that have clinics that may be able to help you. So that's a great resource.
The PTRC, which is the Patent and Trademark Resource Centers, essentially is a nationwide network of libraries. Sometimes they're co-located at a university or a public library in a city or in a state. There you see all the dots with the various locations. And they have special librarians that are equipped to help you do patent searches or trademark searches to get more information about the field of invention that you're working on. So these are really good resources that you can perhaps, depending on where you live around the nation, you can actually go and visit them in person. And
lastly, we've reached our second to last slide. There's some other USPTO resources for you. We have a helpline. You can write that down. It's an 800 number, and you can get some general information, and they'll probably redirect you to some of these other things that we've talked about, places to get help. But we also have these website resources on Utility Patent Application Guide, the patent process, patent search guide, inventor and entrepreneur resources, pro se assistance, and also information on what we call the micro entity. There's a fee schedule that we have that has 3 fees. Large entity, those are the big companies. Think IBM, Xerox's, Facebook's. Then you have medium-sized companies, and then you have micro entity. Micro entity was established recently, and that charges 75% less than the large entities. And so most likely you're going to qualify for micro entity. You can go to that website to read more information about it, but these are all more ways for us to help you, the inventor.
This has been a great journey on behalf of the United States Patent and Trademark Office, the Office of Education. We want to thank you for listening today. We welcome you to come visit us at uspto.gov/kids, as shown on the slide, to learn more about how intellectual property can help you in your science and engineering research projects. And we wish you continued success in your ISEF projects, and look forward to seeing you again soon.
Yes, happy inventing.